Part 2. The Legislative Department. Who may exercise legislative power? Congress. Question. Discuss the legislative power of the Congress. Legislative power, which is the power to propose, enact, amend, and repeal laws, is vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives, except to the extent reserved to the people by the provisions on initiative and referendum. Regional local legislative power. Who exercises regional or local legislative power? Local legislative power shall be exercised by Sangguniang Panlalawigan for the province, the Sangguniang Panlungsod for the city, the Sangguniang Bayan for the municipality, the Sangguniang Barangay for the barangay. Question. What is the nature of the legislative power of local government units? The power of local government units to legislate and enact ordinances and resolutions is merely a delegated power from Congress. Hence, ordinances should not contravene an existing statute enacted by Congress. The legislative branch. Classification of legislative power. Number 1. Original legislative power. This is possessed by the sovereign people. Number 2. Derivative legislative power, that which has been delegated by the sovereign people to the legislative bodies. Kind of power vested in Congress. This is the power vested in Congress. Then constituent, the power to amend or revise the Constitution. Number 4, ordinary, power to pass ordinary laws, legislative power exercised by the people. The people, through the amendatory process, exercise constituent power, and through initiative and referendum, ordinary legislative power. So the classification of legislative power are original legislative power, derivative legislative power, constituent, and ordinary. Scope of legislative power. Congress may legislate on any subject matter. In other words, the legislative power of Congress is plenary. Letter E. Limitations on legislative power. Substantive limitations. Procedural limitations. Substantive limitations. A. Express limitations are Bill of Rights, on appropriations, on taxation, on constitutional appellate jurisdiction of the Supreme Court. No law granting a title of royalty or nobility shall be enacted. Implied limitations. Congress cannot legislate irrepealable laws. Congress cannot delegate legislative powers. Non-encroachment on powers of other departments. Number 2, procedural limitations. Only one subject. Letter B, 3 readings on separate days. Letter C, printed copies in its final form 3 days before passage of the bill. Letter F, non-delegability of legislative power. Doctrine of non-delegation of legislative powers. The rule is delegata potestas non potest delegari. What has been delegated cannot be delegated. Delegata potestas non potest delegari. What has been delegated cannot be delegated. The doctrine rests on the ethical principle that a delegated power constitutes not only a right, but a duty to be performed by the delegate by the instrumentality of his own judgment and not through intervening mind of another. Rationally of the doctrine of non-delegability. Number 1, based on the separation of powers. And number 2, based on due process of law. Such precludes the transfer of regulatory functions to private persons. Number 3, based on the maxim delegata potestas non potest delegari, meaning what has been delegated already cannot be further delegated. Delegata potestas non potest delegari. Letter H. Valid delegation of legislative powers. General rule, legislative power cannot be delegated. Exception, delegation of tariff power to the President. Number 2, delegation of emergency powers to the President. Number 3, delegation to the local government unit. Delegation of rule-making powers. What is delegated to administrative bodies is not legislative power but rule-making power or law execution. Administrative agencies may be allowed either to fill up the details on otherwise complete statute or ascertain the facts necessary to bring a contingent law or provision into actual operation. Power of subordinate legislation. It is the authority of the administrative body tasked by the legislature to implement laws, to promulgate rules and regulations, to properly execute and implement laws. Contingent legislation, the standby authority given to the President to increase the value of added tax rate in VAT law. RA 9337 was upheld as an example of contingent legislation where the effectivity of the law is made to depend on verification by the executive of the existence of certain conditions. Delegation of powers. What is the rule on delegation of powers? The general rule is potestas delegata non delegari potest. Power delegated cannot further be delegated. This is based on the ethical principles that delegated power constitutes not only a right but a duty to be performed by delegate through the instrumentality of his own judgment and not through the intervening mind of another. As an adjunct to the separation of powers principle, legislative power shall be exclusively exercised by the body to which the Constitution has conferred the same. It is clear that only Congress, acting as a bicameral body, and the people, through the process of initiative and referendum, may constitutionally wield legislative power and no other. The premise embodies the principle of non-delegability of legislative power. Belgica versus Ochoa, November 2013. When is delegation of powers permissible? So, kanus permissible ang delegation of powers? Number 1, delegation to the people at large. Examples: A. System of initiative and referendum. Article 6, Section 32 of the Constitution. Letter B. Requirement of plebiscite in the creation, division, merger, and abolition of the local government units. Article 10, Section 10 of the 1987 Constitution. And letter C. The Initiative and Referendum Act, RA 6735. Number 2, the second permissible delegation is emergency powers of the President, which is Article 6, Section 23, Paragraph 2 of the Constitution. Number 3, tariff powers of the President, Article 6, Section 28, Paragraph 2 of the Constitution. Number 4, delegation to administrative bodies, power of subordinate legislation. And number 5, delegation to local government units. Question: what are the tests for valid delegation? Number 1, the tests for valid delegation are completeness test, and number 2, sufficient standard test. Completeness test: the law is complete when it sets forth therein the policy to be executed, carried out, or implemented by the delegate. And sufficient standard test: to be sufficient, the standard must specify the limits of the delegate's authority, announce the legislative policy, and identify the conditions under which it is to be implemented. Limits on the legislative power of Congress. Number 1, substantive. Limitations on the content of laws. Example: no law shall be passed establishing a state religion. Number 2, procedural. Limitations on the manner of passing laws. Example: generally a bill must go through 3 readings on 3 separate days. Its concept is the legislative power of the people through initiative and referendum. People's initiative on statutes. Initiative and referendum. Question: what is a people's initiative? People's initiative is the power of the people to propose amendments to the Constitution or to propose or enact legislation through an election called for the purpose. RA number 6735, Section 3, Paragraph A. Note, RA number 6735, also known as the People's Initiative and Referendum Act, is incomplete, inadequate, or wanting in essential terms and conditions insofar as initiative on amendments to the Constitution is concerned. There is no need to revisit this court's ruling in Santiago declaring RA number 6735 incomplete, inadequate, or wanting in essential terms and conditions to cover the system of initiative to amend the Constitution. However, in the Supreme Court's minute resolution denying the motion to reconsider the dismissal of the petition for People's Initiative, 10 members of the court reiterated their position, as shown by their various opinions already given when the Lambino decision was promulgated, that RA number 6735 is sufficient and adequate to amend the Constitution through a People's Initiative. Minute Resolution, Lambino versus Comelec, October 2006. It may be argued then that this minute resolution has the effect of reversing the Santiago ruling. The COMELEC subsequently promulgated on January 2, 2007, Resolution number 7796, setting forth the rules and regulations to govern the conduct of initiative on the Constitution. Question: what are the three classes of people's initiative? Number 1, initiative on the Constitution. 2, initiative on statutes. 3, initiative on local legislation. Number 1, initiative on the Constitution is the petition proposing amendments to the Constitution. Number 2, initiative on statutes is the petition proposing to enact a national legislation. And number 3, initiative on local legislation, petition proposing to enact a regional, provincial, city, municipal, or barangay law, resolution, or ordinance. What is referendum? Referendum is the power of the electorate to approve or reject legislation through an election called for that purpose. So to distinguish, ang initiative has three classes of people's initiative. Initiative on the Constitution, which is the petition proposing amendments to the Constitution. Number 2, initiative on statutes, which is the petition proposing to enact a national legislation. And number 3, initiative on local legislation, which is the petition proposing to enact a regional, provincial, city, or municipal or barangay law, resolution, or ordinance. On the other hand, referendum is the power of the electorate to approve or reject legislation through an election called for that purpose. Question: what are the classes of referendum? There are two classes of referendum, to wit, referendum on statutes, petition to approve or reject an act or law or part thereof passed by Congress. Referendum on local laws. Referendum on local laws. Referendum on local laws, legal process whereby the registered voters of the local government units may approve, amend, or reject any ordinance enacted by the Sanggunian. So there are also two classes of referendum. Referendum is the petition to approve or reject an act or law or part thereof passed by Congress. Referendum on local laws is the legal process whereby the registered voters of the local government units may approve, amend, or reject any ordinance enacted by the Sanggunian. Bicameral Congress. There are Congress is composed of Senate 1 and the House of Representatives. So Senate. What is the composition of the Senate of the Philippines? The Senate shall be composed of 24 senators who shall be elected at large by the qualified voters of the Philippines as may be provided by law. Article 6, Section 2. Question: what are the qualifications of a senator? The following are the qualifications of a senator: natural-born citizen of the Philippines, at least 35 years of age on the day of the election. Number 3, able to read and write. Number 4, registered voter. And number 5, resident of the Philippines for not less than 2 years immediately preceding the day of the election. Article 6, Section 3 of the Constitution. Question: how long is a Senate's term of office? The term of office of the Senate shall be 6 years and shall commence, unless otherwise provided by law, at noon on the 30th day of June next following their election. No senator shall serve for more than 2 consecutive terms. Voluntary renunciation of office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. House of Representatives. District representatives and questions of apportionment. Question: what is the prescribed composition of the House of Representatives? The House of Representatives shall be composed of not more than 250 members, unless otherwise provided by law, consisting of number 1, district representatives, not less than 200 members, elected from legislative districts apportioned among the provinces, cities, and metropolitan Manila area. Article 6, Section 5, Paragraph 1 of the Constitution. Number 2, party list representative shall constitute 20% of the total number of representatives elected through a party list system of registered national, regional, and sectoral parties or organizations, RA number 7941. One half of the seats allocated to the party list representative shall be filled as provided by law by selection or election from the labor, peasant, urban poor, indigenous cultural communities, women, youth, and such other sectors as may be provided by law, except the religious sector. Article 6, Section 5, Paragraph 2. These members are referred to as sectoral representatives. What are the qualifications to become a member of the House of Representatives? A person must meet the following qualifications. Number 1, natural-born citizen of the Philippines. Number 2, at least 25 years of age on the day of the election. 3, able to read and write. 4, except the party list representatives, a registered voter in the district in which he shall be elected. And number 5, a resident thereof for a period of not less than 1 year immediately preceding the day of the election. Question: what is the term of office of the members of the House of Representatives? What is the term of office of the members of the House of Representatives? The members of the House of Representatives shall be elected for a term of 3 years, which shall begin, unless otherwise provided by law, at noon on the 30th day of June next following their election. No member of the House of Representatives shall serve for more than 3 consecutive terms. Voluntary renunciation of office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. Question: what are the rules in the apportionment of legislative districts? Answer: the following rules govern the apportionment of legislative districts. 1. Shall be made in accordance with the number of respective inhabitants and on the basis of a uniform and progressive ratio. Number 2. Each city with not less than 250,000 inhabitants is entitled to at least 1 representative. Each province, irrespective of the number of inhabitants, entitled to at least 1 representative. Note: 250,000 minimum population is only required for a city but not for a province. Number 3, each legislative district shall comprise as far as practical, contiguous, compact, and adjacent territory. Again, the rules in apportionment of legislative district. Number 1 shall be made in accordance with the number of respective inhabitants and on the basis of a uniform and progressive ratio. Number 2, each city with not less than 250,000 inhabitants is entitled to at least one representative. Each province, irrespective of the number of inhabitants, entitled to at least one representative. Article 6, Section 5, Paragraph 3. The 250,000 minimum population is only required for a city but not for a province. Each legislative district shall comprise, as far as practical, contiguous, compact, and adjacent territory. Article 6, Section 5, Paragraph 3 of the Constitution. Party list system. Next concept, party list system. What is party list system? The party list system is a mechanism of proportional representation in the election of representatives to the House of Representatives from national, regional, and sectoral parties or organizations or coalitions thereof registered within the COMELEC. The Party List System Act, RA number 7941, Section 3. So the party list system is a mechanism of proportional representation in the election of representatives to the House of Representatives from the national, regional, and sectoral parties or organizations or coalitions thereof registered with the COMELEC. Question: what is the purpose of the party list system? The purpose of the party list system is to enable certain Filipino citizens, especially those belonging to marginalized and underrepresented sector, organizations, and parties, to be elected to the House of Representatives. Ang Bagong Bayani OFW Labor Party versus COMELEC, June 2001. What are the qualifications for a person to become a party list nominee? The following qualifications must be met by a person to become a party list nominee. Number 1, natural-born citizen. 2, at least 25 years of age on the day of the election. In case of the youth sector, he must be at least 25 but not more than 30 years old on the day of the election. Number 3, able to read and write. Number 4, a registered voter. Number 5, a resident of the Philippines for a period of not less than 1 year immediately preceding the day of the election. And number 6, a bona fide member of the party or organization which he seeks to represent for at least 90 days preceding the day of the election. Again, natural-born citizen, at least 25 years of age on the day of the election. In case of the youth sector, he must be at least 25 but not more than 30 years old on the day of the election. Number 3, able to read and write. Number 4, a registered voter. 5, a resident of the Philippines for a period of not less than 1 year immediately preceding the day of the election. Number 6, a bona fide member of the party or organization which he seeks to represent for at least 90 days preceding the day of the election. Question: what are the parameters in the election of a party list? There are 4 parameters in the party list election in the Philippines. Number 1, the 20% allocation. 20% of the total number of the members of the House of Representatives is the maximum number of seats available to party list organizations, such that there is automatically one party list for every 4 existing legislative districts, a guaranteed seat for a party list organization garnering 2% of the total votes cast. The guaranteed seats shall be distributed in a first round of seat allocation to parties receiving at least 2% of the total party list votes. Number 3, proportional representation. The additional seats, that is, the remaining seats after allocation of the guaranteed seats, shall be distributed to the party list organizations, including those that received less than 2% of the total votes. Number 4, 3-seat cap. Each qualified party, regardless of the number of votes it actually obtained, is entitled only to a maximum of 3 seats. Discuss the constitutionality of the 2% threshold prescribed under RA 7941 for the distribution of additional party list seats. The Supreme Court in Banat v. Comelec struck down an unconstitutional as unconstitutional the 2% threshold in the distribution of additional party list seats in the second clause of Section 11, Part B, RA number 7941. The court held that continued operation of the 2% threshold in the distribution of additional seats frustrates the attainment of the permissive ceiling that 20% of the members of the House of Representatives shall consist of party list representatives. Question: what is the effect of a change in affiliation of any elected party list representative? Any elected party list representative who changes his political party or sectoral affiliation during his term of office shall forfeit his seat, provided that if he changes his political party or sectoral affiliation within 6 months before an election, he shall not be eligible for nomination as party list representative under this new party or organization. What is the rule on vacancies in the seats of party list representative? In case of vacancy in the seats reserved for party list representative, the vacancy shall be automatically filled by the next representative from the list of nominees in the order submitted to COMELEC by the same party, organization, or coalition, who shall serve for the unexpired term. If the list is exhausted, the party, organization, or coalition concerned shall submit an additional nominee. Question: may the COMELEC allow the substitution of nominees of party list for causes other than those provided under RA number 7941? No. The COMELEC, despite its role as the implementing arm of the government in the enforcement and administration of laws and regulations relative to the conduct of an election, has neither the authority nor license to expand, extend, or add anything to the law it seeks to implement thereby. The IRRs the COMELEC issues for that purpose should always be in accord with the law to be implemented and should not override, supplant, or modify the law. It is basic that the IRRs should remain consistent with the law they intend to carry out. Lokin versus COMELEC, June 2010. Question: may the registration of a party list be cancelled and qualifications of nominees be questioned after it had been proclaimed winner in the elections? Yes. The Constitution grants the COMELEC the authority to register political parties, organizations, or coalitions, and the authority to cancel the registration of the same on legal grounds. The said authority of the COMELEC is reflected in Section 6 of RA number 7941. In the case of the party list nominees representatives, it is the House of Representatives Electoral Tribunal that has jurisdiction over contests relating to their qualifications. Although it is the party list organization that is voted for in the elections, it is not the organization that sits as and becomes a member of the House of Representatives, but it is the party list nominee representative who sits as a member of the House of Representatives. Legislative privileges, inhibitions, and disqualifications. Question: what are the rules? Legislative privileges: disclosure of financial and business affairs, prohibitions, inhibitions, and disqualifications. Question: what are the rules on compensation of senators and members of House of Representatives? Answer: the salaries of senators and members of the House of Representatives shall be determined by law. No increase in said compensation shall take effect until after the expiration of the full term of all the members of the Senate and the House of Representatives approving such increase. Question: what are the immunities granted to the members of Congress? The following are the immunities of senators and House of Representatives. Number 1. Privilege from arrest. In all offenses punishable by not more than 6 years imprisonment, a senator or a member of the House shall be privileged from arrest while the Congress is in session. So again, in all offenses punishable by not more than 6 years imprisonment and while Congress is in session. Um, if that is the case, a senator is privileged from arrest. It is available while Congress is in session, whether the session is regular or special, or whether or not the legislator is actually attending his session. Session covers the entire period from its initial convening until its final adjournment. The members of Congress are not exempt from detention for crime punishable by more than 6 years of imprisonment. Kung more than 6 years of imprisonment yung punishment sa crime, Congress are not exempt from detention. So there is no privilege from arrest. Number 2, parliamentary privilege of speech. They shall not be questioned. So the Congress, the Senate, and the members of House of Reps shall not be questioned nor be held liable in any other place or any speech or debate in Congress or in any commitment thereof. Etong parliamentary privilege of speech. Parliamentary privilege of speech means the Senate and the House of Reps shall not be questioned nor be held liable in any other place or any speech or debate in Congress or in any commitment thereof. However, he can be subjected to disciplinary action by the Congress itself. This is Chavez versus JBC, April 2013. What are the requisites to avail the privilege of speech and debate? The following are the requisites. Number 1, the remarks must be made while the legislature or the legislative committee is in session. Number 2, that they must be made in connection with the discharge of official duties. Jimenez versus Cabangbang, August 1966. Again, the requisites to avail of the privilege of speech and debate are 1, that the remark must be made while the legislature or legislative committee is in session, and that they must be made in connection with the discharge of official duties. Question: what are the prohibitions imposed upon members of Congress? The following are the disqualifications and inhibitions imposed upon them. Number 1, incompatible office, and number 2, forbidden office. Incompatible office means no senator or member of the House of Representatives may hold any other office or employment in the government or any subdivision, agency, or instrumentality thereof, including GOCCs or their subsidiaries during his term, without forfeiting his seat. The general rule is they cannot simultaneously hold the incompatible office while serving their term in office. The exception is if it is shown that said other office or employment is an extension of the legislative position or is in aid of legislative duties or is held by them in an ex officio capacity. Number 2, forbidden office. Neither shall he be appointed to any office which may have been created or the emoluments thereof increased during the term of which he was elected. Forbidden office. Neither he shall be appointed to any office which may have been created or the emoluments thereof increased during the term for which he was elected. Question: what are the parliamentary prohibitions imposed upon members of Congress? Parliamentary prohibitions. The senators and members of the House of Representatives, number 1, shall not personally appear as counsel before any court of justice or before the electoral tribunals or quasi-judicial and other administrative bodies. Number 2, he shall not directly or indirectly be interested financially in any contract with or in any franchise or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including any GOCC or its subsidiary during his term. Number 3, he shall not intervene in any matter before any office of the government of his pecuniary benefit or where he may be called upon to act on account of his office. So the parliamentary prohibitions imposed upon members of Congress are: number 1, senators and members of Congress shall not personally appear as counsel before any court of justice or before the electoral tribunals or quasi-judicial and other administrative bodies. Number 2, he shall not directly or indirectly be interested financially in any contract with or in any franchise or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including any GOCC or its subsidiary during his term. Number 3, he shall not intervene in any matter before any office of the government of his pecuniary benefit, or where he may be called upon to act on account of his office. Question: may members of Congress practice their profession? Answer: yes. As to the members of Congress, there is no general prohibition as to the practice of their profession. Question: Juan de la Cruz holds 99.1% of the outstanding capital stock of Stretch Rubber Corporation, a domestic corporation engaged in the business of manufacturing garters, tires, elastic bands. Pursuing his lifetime dream of becoming a member of the legislature, he ran and was elected as senator during his term. Stretch Rubber Corporation was awarded with a contract with the government. Upon knowledge of this, its competitor Fire Tire Corporation questioned the validity of the contract, invoking that Juan de la Cruz was disqualified under the law as senator to benefit from the contract. In the defense, Juan de la Cruz averred the principle of separate personalities between him and Stretch Rubber Corporation. Will the suit prosper? Yes. The suit of Fire Tire Corporation will prosper. A senator shall not be interested financially, directly or indirectly, in any contract with or in any franchise or special privilege granted by the government during his term. Article 6, Section 14. In this case, Juan de la Cruz, as the majority stockholder of Stretch Rubber Corporation, will indirectly benefit from the grant of the franchise because of his equity in the same. He cannot hide behind the defense of separate personalities between him and the corporation, as the law prohibits indirect financial interest. Next concept: quorum and voting majorities. Quorum. Question: what is quorum? What is the quorum prescribed for the House of Congress? A majority of all the members of each house shall constitute a quorum, but a smaller number may adjourn from day to day and may compel the attendance of the absent members in such manner and under such penalties as such house may determine. The existence of a quorum is based on the proposition between those physically present and the total membership of the body. So, majority of all the members of each house shall constitute a quorum, but a smaller number may adjourn from day to day and may compel the attendance of the absent members in such manner and under such penalties as such house may determine. Question: Senator Juan de la Cruz is abroad for a family vacation. Senator Pedro Santos is sick and in comatose condition, confined in the Philippines. Senator Maria Reyes is in prison. Determine the quorum of the Senate. The basis in determining the existence of a quorum in the Senate shall be the total number of incumbent senators who are in the country and within the coercive jurisdiction of the state. This is Avellino versus Cuenco, March 1949. Thus, Senator Juan de la Cruz is not counted in determining the quorum. However, Senator Pedro Santos and Maria Reyes are still counted, since they are within the coercive jurisdiction of the state, on the assumption that all the 23 seats in the Senate are filled. Quorum is 12 senators. Define majority of all members of Congress. Majority of all members of Congress means majority of the entire composition of Congress, regardless of the number of members present or absent during the time the question is brought to the floor, as long as there is quorum. So 24 divided by 2 plus 1 for Senate, and 250 divided by 2 plus 1 for the House of Representatives. Majority of all the members of Congress is an absolute number. Avellino versus Cuenco, March 1949. For example, when there were only 23 senators after the election of former Senator Benigno Aquino as president, majority of all the members of Congress, insofar as the Senate is concerned, is still 13, even if there is one vacancy in the Senate. Question. Define majority of the House. Majority of the House means majority of the incumbent members who are within the coercive jurisdiction of Congress. Using the example in the immediate preceding paragraph, majority of the House, insofar as the Senate is concerned, means 12, assuming that all the 23 senators are within the coercive jurisdiction of the Senate. So defining majority of all the members of Congress. Majority of all members of Congress means majority of the entire composition of Congress, regardless of the number of members present or absent during the time. The question is brought to the floor as long as there is a quorum. So majority of the members of Congress is an absolute number. For example, when there were only 23 senators, For example, when there were only 23 senators after the election of former Senator Benigno Aquino as president, majority of all the members of Congress, insofar as the Senate is concerned, is still 13, even if there is one vacancy in the Senate. Majority of the House means majority of the incumbent members who are within the coercive jurisdiction of Congress. Using the example in the immediate preceding paragraph, majority of the House, insofar as the Senate is concerned, means 12, assuming that all the 23 senators are within the coercive jurisdiction of Senate. Discipline of members. Discipline. The next concept is discipline of members. What is the rule on disciplining members of Congress? Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 of all its members, suspend or expel a member. A penalty of suspension, when opposed, shall not exceed 60 days. So each House may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 of all its members, suspend or expel a member. A penalty of suspension, when imposed, shall not exceed 60 days. Article 6, Section 16, Paragraph 3 of the Constitution. Next concept is process of lawmaking. Functions of the Bicameral Conference Committee. Bicameral Conference Committee. Question. Discuss the functions of the Bicameral Conference Committee. In a bicameral system, bills are independently processed by both houses of Congress. The Conference Committee, consisting of members nominated from both houses, is an extra constitutional creation of Congress whose function is to propose to Congress ways of reconciling conflicting provisions found in Senate version and House version of the bill. It performs necessary function in a bicameral system. They should not, however, perform functions that the Congress itself may not do. Moreover, their proposals need confirmation by both houses of Congress. Discuss the functions of Bicameral Conference Committee. In a bicameral system, bills are independently processed by both houses of Congress. Bills are independently processed by both houses of Congress. The Conference Committee, consisting of members nominated from both houses, is an extra constitutional creation of Congress whose function is to propose to Congress ways of reconciling conflicting provisions found in the Senate version and House version of the bill. It performs necessary function in a bicameral system. They should not, however, perform functions that the Congress itself may not do. Moreover, their proposals need confirmation by both houses of Congress. Question: can the bicameral conference committee propose an entirely new provision that is not found either in the House bill or in the Senate bill? Yes, it is within the power of a conference committee to include in its report an entirely new provision that is not found either in the House bill or in the Senate bill. If the committee can propose an amendment consisting of one or two provisions, there is no reason why it cannot propose several provisions collectively considering as an amendment, collectively considered as an amendment in the nature of a substitute, as long as such amendment is germane to the subject of the bills before the committee. After all, its report was not final but needed the approval of both houses of Congress to become valid as an act of legislative department. Tolentino versus Secretary of Finance, August 1994. So, can a bicameral conference committee propose an entirely new provision that is not found either in the House bill or in the Senate bill? Yes, it is within the power of a conference committee to include in its report an entirely new provision that is not found either in the House bill or in the Senate bill. If the committee can propose an amendment consisting of one or two provisions, there is no reason why it cannot propose several provisions collectively considered as an amendment to the nature of a substitute in the nature of a substitute, so long as such amendment is germane to the subject of the bills before the committee. Limitations on legislative power. Limitations on revenue appropriation and tariff measures. Number 1. What are revenue appropriations and tariff bills? Number 1. Question: what are revenue appropriations and tariff bills? Revenue bill is a bill that is specifically designed to raise money or revenue through levy. Appropriation bill is a bill primary and specific purpose of which is to authorize the release of funds from public treasury, and tariff bill is a bill that specifies the rates or duties to be imposed on import articles. So to distinguish, revenue bill is a bill that is specifically designed to raise money or revenue through levy, whereas appropriation bill is a bill the primary and specific purpose of which is to authorize the release of funds from the public treasury. Ang tariff bill is a bill that specifies the rates or duties to be imposed on imported articles. What are the express limitations on revenue, appropriation, and tariff measures of the Congress? Answer: the following are the limitations on the said measures. Number 1. All appropriation, revenue, or tariff bills authorizing increase of public debt, bills of local application, and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. This is Article 6, Section 24 of the Constitution. The exclusivity of the prerogative of the House of Representatives means simply that the House alone can initiate the passage of a revenue bill. The House alone can initiate the process of a revenue bill such that if the House does not initiate one, no revenue law will be passed. But once the House has approved a revenue bill and passed it on to the Senate can completely overhaul it by amendment of parts or by amendment of substitution and come out with one completely different from what the House approved. Tolentino versus Secretary of Finance, August 1994. Number 2. The general appropriation law must be based on the budget prepared by the President. This is Article 7, Section 22 of the Constitution. The form, content, and manner of the preparation of budget shall be provided by law. Article 6, Section 25, Paragraph 1 of the Constitution. And then number 3, Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. Article 6, Section 25, Paragraph 1 of the Constitution. Congress may not increase the appropriation revenue Appropriations recommended by the President for the operation of the government as specified in the budget. Number 4. No provision or enactment shall be embraced in the General Appropriations Bill unless it relates specifically to some particular appropriation therein. Article 6, Section 25, Paragraph 2 of the Constitution. No provision or enactment shall be embraced in the General Appropriations Bill unless it relates specifically to some particular appropriation therein. Number 5. A special appropriations bill shall specify A. Purpose for which it is intended, and B. Shall be supported by funds actually available as certified by the National Treasurer or to be raised by a corresponding revenue proposal therein. Number 6. Prohibition against transfer of appropriations. Doctrine of augmentation. The President, Senate President, Speaker of the House, Chief Justice of the Supreme Court, and heads of constitutional commissions may by law be authorized to augment any item in the General Appropriations Law for their respective offices from savings in other items of their respective appropriation. This is Article 6, Section 25, Paragraph 5 of the Constitution. So, prohibition against transfer of appropriations, doctrine of augmentation. The President, Senate President, Speaker of the House, Chief Justice of the Supreme Court, and heads of the Constitution may by law be authorized to augment any item in the General Appropriations Law for their respective offices from savings or in other items of their respective appropriation. Number 7. Discretionary funds appropriated for particular officials shall be dispersed only for public purposes. Number 8. Automatic reappropriation. If by the end of any fiscal year, the Congress shall have failed to pass the General Appropriations Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the General Appropriations Bill is passed by Congress. Section 29, Paragraph 2 prohibits appropriations for sectarian benefit, and aside from the express exceptions, payment of public funds is prohibited to ecclesiastics only as such, which means that they may be paid from public funds if they serve the government in a non-ecclesiastical capacity. Number 10. One title, one subject rule. Every bill passed by Congress shall embrace only one subject, which shall be expressed in the title thereof. Article 6, Section 26, Paragraph 1. The purpose of this rule involves the prevention of hodgepodge or log-rolling legislation, which contains several subjects dealing with unrelated matters representing diverse interests, prevention of surprise or fraud upon the legislature, and the fair appraisal of the people. Question. What are the implied limitations on the power of Congress to appropriate? The following are the implied limitations on the said power. Number 1. Appropriation must be devoted to a public purpose. And number 2. The sum authorized to be released must be determinate or at least determinable. Presidential veto and congressional override. Discuss the rules on presidential veto. Okay. The general rule is that the president must approve entirely or disapprove in toto. The exception to this rule is in the case of appropriation, revenue, and tariff bills, where item veto is allowed. However, there are exceptions to this exception, namely, number 1, doctrine of inappropriate provisions. A provision that is constitutionally inappropriate for an appropriation bill may be singled out for veto even if it is not an appropriation or revenue item. Gonzalez versus Macaraig, November 1990. Number 2, executive impoundment. Refusal of the President to spend funds already allocated by Congress for a specific purpose. It is the failure to spend obligate budget authority of any type. Felconsa versus Enriquez. So, exceptions exceptions to this exception. So, ang general rule, atong balikon, ang general rule, let's go back, babalikan natin. The general rule is that the president must approve entirely or disapprove in toto. Approve entirely or disapprove in toto. Ang exception to this rule is in case of appropriation, revenue, and tariff bills, wherein item veto is allowed. However, there is an exception to this exception. So, an exception to the item veto rule is, number 1, the doctrine of inappropriate provision. So, a provision that is constitutionally inappropriate for an appropriation bill may be singled out for veto even if it is not an appropriation or revenue item. So, even if it is not an appropriation or revenue item veto can be made if item veto can be made if there is an inappropriate provision. So if there is an inappropriate provision, item veto can be made, although it is not a revenue or it is not a revenue bill. It's not an appropriation, revenue, and tariff bill. Number 2, executive impoundment. So, refusal of the president to spend funds already allocated by Congress for specific purposes. It is a failure to spend or obligate budget authority of any type. Falconza versus Enriquez. Discuss the rules on congressional override. If the president exercises his power to veto, he must return the bill with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. The House may either 1. Take into account the objections made by the President and make corresponding amendments in the bill. The bill, as amended, will again be presented to the President for his approval. Or number 2, invalidate the veto and convert the bill into law over the object of the President when concurred by the veto of 2/3 of all the members of each House. Congressional override. If the President exercises his power to veto, he must return the bill with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. So, if the President decides to veto the bill, he must return the bill with his objections to the House where it originated. And then the House may either, in return, the House where the bill originated may either, number 1, take into account the objection made by the President and make corresponding amendments in the bill. The bill, as amended, will again be presented to the President for his approval. Number 2, invalidate the veto. So the House where it originated may also invalidate the veto and convert the bill into law over the objection of the President when concurred by the vote of 2/3 of all the members of each House. Question: when must the President communicate his veto? The President shall communicate his veto of any bill to the House where it originated within 30 days after the date of the receipt thereof. Otherwise, it shall become a law as if he had signed it. 30 days. So 30 days after the date of the receipt thereof. Otherwise, it shall become a law as if he had signed it. What is pocket veto? Vetoing of a bill by an executive by not acting in time given by the law. So, pocket veto, an invalid veto is without effect. Example, it is as if the President did not act on the bill at all. Hence, the bill becomes a law by executive inaction. Bolinao Electronics versus Valencia. So what is pocket veto? Vetoing of a bill by an executive by not acting in the time given by law. So what time is given by law? It is 30 days from the date of receipt thereof. So the President shall communicate his veto of the bill to the House where it originated within 30 days after the date of receipt thereof. The Constitution. The Constitution, our laws, and the ruling of the Supreme Court on the Disbursement Acceleration Program, Aurelio versus Aquino, DAP, have provided enough leeway for the President to realign the budget, augment funding, and act on a crisis and emergency of this magnitude like COVID-19 pandemic. The minority leader pointed to specific provisions of the Constitution and various laws to declare savings and realign funds in order for the government to respond to COVID-19. The President is authorized to suspend the expenditure of appropriations, declare savings, and realign the same under Article 6, Section 25 of the Constitution, Section 38 and 39 of the Revised Administrative Code, and Section 66, the 2020 General Appropriations Act. He can exercise all these powers in order to respond to COVID-19 pandemic. Next concept, electoral tribunals and the Commission on Appointment. Question: what is the composition of electoral tribunals? Each electoral tribunal shall be composed of 9 members, 3 of whom shall be justices of the Supreme Court to be designated by the Chief Justice, and the remaining 6 shall be members of the Senate or the House of Representatives, as the case may be, who shall be chosen on the basis of proportional representation from political parties and parties or organizations registered under the party list system represented therein. The senior justice in the electoral tribunal shall be its chairman. Question: when must the electoral tribunal be constituted? The electoral tribunals shall be constituted within 30 days after the Senate and the House of Representatives shall have been organized with the election of the President and the Speaker. Question: discuss the independence of the respective electoral tribunals of the Houses of Congress. The Electoral Tribunal is independent of the Houses of Congress. Angara versus Electoral Commission, and its decisions may be reviewed by the Supreme Court only upon showing of grave abuse of discretion in a petition for certiorari filed under Rule 65. This means that each electoral tribunal is not subject to the control of the House to which it pertains, and its decisions can only be corrected by the Supreme Court through a special remedy of certiorari. Powers. What is the function of the Electoral Tribunal? The Electoral Tribunal acts as the sole judge of all contests relating to the election, returns, and qualifications of the respective members of each House. Question: when does the House of Representatives Electoral Tribunal acquire jurisdiction over election cases? Once a winning candidate has been proclaimed, taken his oath, and assumed office as a member of the House of Representatives, COMELEC's jurisdiction over the election contests relating to his election returns and qualification ends, and the House of Representatives Electoral Tribunal's own jurisdiction begins. Lim Kai-chong versus COMELEC, April 2009. Question: what is the jurisdiction of the HRET over party list cases? The House of Representatives Electoral Tribunal decides whether a party list representative is qualified, but the COMELEC can decide whether a party list organization is qualified to join the party list system. Abayon versus COMELEC, February 2010. Commission on Appointment. Nature. What is the composition of the Commission on Appointment? There is to be a Commission on Appointment consisting of the President of the Senate as ex officio chairman, 12 senators, 12 members of the House of Representatives elected by each House on the basis of proportional representation from the political parties and the parties or organizations registered under the party list system. represented therein. So, question: when must the COA be constituted? The Commission on Appointment shall be constituted within 30 days after the Senate and the House of Representatives shall have been organized with the election of the President and the Speaker. Question: discuss the independence of the Court Commission on Appointment. The Commission is independent of the two houses. Its employees are not technically employees of Congress. It has the power to promulgate its own rules and proceedings. Powers. What is the function of the Commission on Appointment? The Commission on Appointment acts as a legislative check on the appointing authority of the President for the effectivity of the appointment of certain key officials enumerated in the Constitution. The consent of the Commission on Appointment is needed. Discuss the voting rules of the Commission. The Commission shall rule by a majority vote of its members. Chairman shall not vote except in case of a tie. So, what are the rules on meeting of the Commission? The Commission shall meet only while Congress is in session at the call of its chairman or the majority of all its members. Article 6, Section 19 of the Constitution. Next concept: powers of Congress. Legislative inquiries and oversight functions. What are legislative or formal inquiries? Legislative inquiries may refer to the implementation or re-examination of any law or appropriation, or in connection with any proposed legislation, or for the formulation of, or in connection with future legislation, or will aid in the review of formulation of a new legislative policy or enactment. They may also extend to any formulation to any and all matters vested by the Constitution in Congress and or in the Senate alone. Section 1, Rules of Procedure governing inquiries in aid of legislation. The inquiry to be within the jurisdiction of the legislative body to make must be material or necessary to the exercise of a power in it vested by the Constitution, such as to legislate or to expel a member. What is the scope of the power of legislative investigation of the Congress? The power of legislative investigation of the Congress involves the following. Number 1, power to conduct inquiry in aid of legislation in accordance with its duly published rules of procedure. Number 2, power to issue summons and notices in connection with the matters subject of its investigation or inquiry. Number 3, power to punish or declare any person. Power to punish or declare a person in contempt during or in the course of legislative investigation. And the power to determine the rules of its proceedings. July Arnold versus Nazareno, July 18, 1950. July 18, 1950. Discuss the oversight function. What are the limitations on the power of legislative investigation of the Congress? The following are the limitations of said power. Number 1, must be in aid of legislation. Number 2, in accordance with the duly published rules of procedures. And number 3, the right of persons appearing in or affected by such inquiry shall be respected. Question: discuss the oversight functions of Congress. The heads of the department may, upon their own initiative, with the consent of the President or upon the request of either House, as the rules of each House shall provide, appear before and be heard by such House, or in any matter pertaining to their departments. Written question shall be submitted to the President of the Senate or to the Speaker of the House of Representatives at least 3 days before their scheduled appearance. Interpellations shall not be limited to written questions, but may cover matters related thereto, when the security of the state or the public interest so requires. The appearance shall be conducted in executive session. Discuss the oversight functions of Congress. The heads of departments may, upon their own initiative, with the consent of the President, or upon the request of either House, as the rules of each House shall provide, appear before and be heard by such House on any matter pertaining to their departments. Written questions shall be submitted to the President of the Senate or to the Speaker of the House of Representatives at least 3 days before their scheduled appearance. Interpellations shall not be limited to written questions, but may cover matters related thereto. When the security of the state or the public interest so require, the appearance shall be conducted in executive session. Question hour. Discuss the question hour vis-a-vis the oversight functions of Congress. The Supreme Court referred to the oversight function of Congress under Section 22, Article 6 as question hour, Senate versus Ermita, April 20, 2006. In the said case, the Supreme Court ruled that Section 21 and 22, therefore, while closely related and complementary to each other, should not be considered as pertaining to the same power of Congress. One specifically relates to the power to conduct inquiries in aid of legislation, the aim of which is to elicit information that may be used for legislation, while the other pertains to the power to conduct a question hour, the objective of which is to obtain information in pursuit of Congress oversight function. So, difference between the right of Congress to conduct inquiry in aid of legislation and its oversight function. As to who may appear. So, right to conduct legislative in aid of legislation, any person may appear. Oversight function, only a department head appears. As to who conducts investigation. So, sa inquiry in aid of legislation, committees conducts the investigation. Oversight function is the entire body. And then, as to subject matter, any matter for the purpose of legislation. Inquiry in aid of legislation, any matter for the purpose of legislation, whilst oversight function, matters related to the department only. Then, as to purpose, inquiry in aid of legislation, Congress has the power to conduct inquiries in aid of legislation, the aim of which is to elicit information that may be used for legislation. And as to purpose again, the oversight function, Congress has the power to question department heads, the objective of which is to obtain information in pursuit of Congress oversight functions. As to attendance, attendance is compulsory in inquiry in aid of legislation, whereas oversight function attendance is discretionary. Hence, it is valid for the President to require that consent be obtained first before subordinates appear in Congress during the question hour. Then, as to attendance, Congress can compel the attendance of executive officials in legislative inquiry, whereas for question hour, Congress cannot request the appearance of executive officials if it required the consent of the President. If the required consent of the President is not obtained first, or no such consent is given. Section 3, Paragraph 1 of the 1987 Constitution. This is Article 11, Section 3, Paragraph 1 of the 1987 Constitution. The House of Representatives shall have the exclusive power to initiate all cases of impeachment. Number 2, a verified complaint for impeachment may be filed by any member of the House of Representatives or by any citizen upon a resolution or endorsement by any member thereof, which shall be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter. The committee, after hearing and by a majority vote of all its members, shall submit its report to the House within 60 session days from such referral, together with the corresponding resolution. The resolution shall be calendared for consideration by the House within 10 session days from receipt thereof. A vote of at least one-third of all the members of the House shall be necessary either to affirm a favorable resolution with the articles of impeachment of the committee or override its constant resolution. The vote of each member shall be recorded. Number 4. In case the verified complaint or resolution of impeachment is filed by at least one-third of all the members of the House, the same shall constitute the articles of impeachment, and the trial by the Senate shall forthwith proceed. Number 5. No impeachment proceedings shall be initiated against the same officials more than once within a period of 1 year. Number 6. The Senate shall have the sole power to try and decide all cases of impeachment when sitting for that purpose. The senators shall be on oath or affirmation. When the President of the Philippines is on trial, the Chief Justice of the Supreme Court shall preside but shall not vote. No person shall be convicted without the concurrence of two-thirds of all the members of Senate. Number 7. Judgment in case of impeachment shall not extend further than removal from office and disqualification to hold any office under the Republic of the Philippines. But the party convicted shall nevertheless be liable and subject to a prosecution, trial, and punishment according to law. Number 8. The Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. So the House of Representatives shall have the exclusive power to initiate all cases of impeachment.